Well, congratulations, Director Lim and Professor So on this inaugural conference on computational legal studies. And thank you for your very kind invitation to be a keynote speaker for this auspicious occasion. Your inaugural theme is computational legal studies, past, present, and future. And I suspect that I'm here to represent the past. After all, I've seen a lot of it. I'm going to focus most of this talk, however, on the recent past and the present. My talk today has two main parts. First, how legal knowledge can help machine learning, and second, how machine learning can help legal knowledge. In part one, I will introduce knowledge-based legal argument prediction and the kind of legal knowledge-rich domain models it employs. Then I will turn to text analytic methods for prediction and their application of statistical machine learning to legal texts. For both of these, I will use examples to underscore some of the complementary benefits of each, as well as their limitations. I will turn then to an example of an effort to extract more legal meaning from case texts. And I will close part one with some speculation about ways to integrate legal knowledge and machine learning. Since graduate school in the 1980s, there have been at least two dramatic shifts in AI and law research. First is a move from modeling legal reasoning with rules, with cases, and with rules and cases, to developing models of legal argument that integrate them all into a unified, knowledge-based approach. Thorne McCarty, who is with us this evening, or this morning for you, started that ball rolling. In my view, it culminated in Matthias Grobmaier's VJAP program in 2017. More recently, there has been a dramatic move away from these knowledge-based models of legal argument to legal text analytics based not on knowledge, but on statistical machine learning. Chalkidis's work on predicting cases of the European Court of Human Rights comes to mind. The move to legal text analytics raises an important question. To what extent can the new machine learning methods explain their legal predictions and answers? In my 2017 book, I argued that knowledge-based argument models can supplement the apparent inability of machine learning methods to generate useful explanations. In that connection, I will turn to the exciting possibilities raised in the 2020 AI and Law Journal paper of Carl Branting and his team. The possibility of moving back to knowledge-based approaches rests on works like his. Knowledge-based legal argument models employ argument schemes to represent patterns of legal argumentation. The schemes are templates or blueprints for typical kinds of legal arguments whose premises can be established based on assumed facts or as conclusions of other argument schemes. For example, argument schemes include arguing deductively from legal rules, by analogy to past cases, or from underlying values. Other schemes address responding to arguments by distinguishing a precedent or citing a trumping counterexample or asking critical questions that undermine the acceptability of the scheme's premises. One inputs the current fact situation, the argument schemes guide a search for a supporting argument or counterargument, and that is added to the argument graph. The process continues until there are no more arguments to add. Then the model evaluates the argument using legal proof standards or other criteria, and outputs a conclusion. So where is the legal knowledge? It relies in the legal proof standards and the other criteria for evaluating the arguments, in the argument schemes, and in the legal reasoning domain model from which the argument schemes are drawn. Let me illustrate a legal domain model for trade secret misappropriation law. As you know, law is a domain of rules, of cases interpreting those rules, and of arguments whether to follow a rule or not. This model addresses legal reasoning with rules and cases governing claims of trade secret misappropriation. It underlies the value judgment-based argumentative prediction program, VJAP for short, developed by my former PhD advisee, Matthias Grobmeier, who is now a professor at TUM in Munich. A set of legal rules defines what a trade secret is and what it is to misappropriate a trade secret. We represented rules from the Uniform Trade Secrets Act and Restatement First of Torts on the left, with the and/or tree in the center. The nodes in the tree are the issues that comprise the elements of the rules. We collected a set of trade secret cases in the bottom middle and represented them with 26 factors, the lower right, linked to the relevant issues in the rules. Factors are stereotypical patterns that strengthen or weaken a side's claim. Some factors favor the plaintiff. For example, if the plaintiff took security measures to protect its confidential information. Other factors favor the defendant, such as if the product information can be reverse engineered. Matthias added a set of values protected by trade secret law in the upper right, such as plaintiff's interest in protecting confidential information or the general public's interest in using publicly available information. And then each value was subject to 4 effects of decisions pro or con, and these were keyed into relevant factors and issues. Value effects include waiving the value, interfering with it, protecting it, or making it less legitimate. So you see, the domain model is a kind of interpretation of the law of a domain, and as such, it contains a lot of legal knowledge. VJAP uses that knowledge. It integrates a kind of argumentative reasoning with legal rules, cases, factors, underlying values, and effects of decisions on values. Given a new case, it generates an argument graph representing all the possible case-based arguments that can be made with all the relevant precedents it has. It propagates confidence values in those arguments based on weights it has learned through simulated annealing. It generates a quantitative prediction based on the highest confidence arguments. In an evaluation of predictive accuracy, it tied naive Bayes, a machine learning algorithm, but it also provided textual arguments with which to explain its prediction. Here is an example of VJAP's textual arguments, citing a case and drawing the analogy. The argument integrates logical reasoning based on the legal rules with case-based analogical reasoning using cases, factors, values, and effects on values, and these are underlined in red. Importantly, a computational model of argument like VJAP does not simply output outcomes or predictions, it also explains a prediction with arguments that lawyers would recognize and understand. Its explanations convey an understanding of the answer in terms of legal knowledge, some indication of how it was obtained, and some information with which to assess whether the answer made sense. Now, I would like to emphasize 3 things. VJAP, of course, depends on manual representation of the legal knowledge in its domain model, including representing cases in terms of factors. In short, it's subject to the knowledge representation bottleneck that affects AI knowledge-based approaches. However, given the rest of its domain model, if factors could be identified automatically, that is all that would be necessary to employ VJAP's ability to generate arguments with the rules, cases, values, and value effects. With these components, it could offer explanations of predictions made by machine learning programs. Third, it's not obvious to me how any program, machine learning or otherwise, can explain predictions of legal outcomes in terms of arguments lawyers will find intelligible without resources like VJAP's legal domain model. But that's what researchers are trying to accomplish as they turn to text analytic legal prediction. Legal text analytics, or text mining, as you know, is a subset of AI and law that employs natural language processing and machine learning automatically to extract some meaning from archives of legal case decisions or contracts or statutes. Legal argument mining is the subset of legal text analytics that focuses on extracting argument-related information from the legal text data. Legal text analytics uses a variety of tools, but in this talk, I will focus on machine learning, in particular, deep learning from texts. Deep learning employs neural networks trained on large databases of texts, an example of big data. Neural networks comprise input-output nodes connected to multiple layers of intermediary nodes via weighted edges. The inputs propagate through the nodes in the network to an output. The process involves the linear combination of weights in the edges. The goal is to learn weights that minimize the deviation of the computed output from the target output. Different architectures of networks, layers, and depths are suitable for different tasks. Deep learning neural networks employ multiple layers. Hidden layers help learn features with predictive weight. Here's the problem. Neural networks learn weights to make predictions, but do not yield accessible explanations. The knowledge, such as it is, resides in weights distributed across the network, and it's difficult to tease that knowledge out of the network with which to fashion explanations. In addition, the weights do not necessarily correspond to the kinds of knowledge that we as legal professionals think is relevant. Indeed, the relevant knowledge for making an explanation may not be even in the network. Chalkitas applied deep learning to predict outcomes of cases before the European Court of Human Rights directly from textual descriptions of their facts. The algorithms predict if the court found a violation of any provisions of the European Convention on Human Rights and of which provisions. The researchers assembled nearly 8,500 cases for training and development and 3,000 cases for testing. Their BERT-based algorithm performed best with quite respectable results. In terms of F1 scores, the harmonic mean of precision and recall, it predicted whether there was a violation with F1 equal 82%. It predicts which provisions were violated with F1 equal 60%. Those results are impressive, especially since their machine learning doesn't employ features that reflect legal knowledge, much less substantive legal merits. No rules, no cases, values, or value effects. Who needs them? Deep learning from cases texts automatically learn features that have weight in determining predictions. Of course, as I mentioned, those learned features do not necessarily correspond to the kinds of legal knowledge legal professionals can understand, even if it could be teased out of the network. Thus, it cannot explain its prediction. What it can do is highlight portions of text that influence its prediction. It employs hierarchical attention networks, HANs, for this purpose. As I mentioned before, different architectures of networks, layers, and depths are suitable for different analytic tasks. Hierarchical attention networks predict case outcomes and yield network attention weights. The figure shows an HAN that computes attention weights for words on the bottom and then for sentences. Attention weights in HANs can highlight relevant portions of documents. This led to the possibility of using HAN highlighting to explain predictions and answers. That's an aim of Chalkidis and others. They want to use hierarchical attention networks in order to tease out from neural networks the constituents of legal explanations. The HANs assign higher attention scores to the portions of text that have greater influence on the model's outcome prediction. An interface then highlights these aspects of the text. The hope is that the highlighted portions will amount to an explanation of the prediction. Chalkidis applied a HAN in generating the highlighted fact description shown here. The model attends more highly to the words colored in various shades of pink and red, and to the fact sentences indicated with vertical heat bars. And you can peruse the highlighted portions. The highlighting makes some sense, but query whether it amounts to an explanation. Carl Branting's experiments suggest that these highlighted high-scoring portions of texts fall short of meaningful explanation. They engaged 61 persons on a task involving analyzing decisions of WIPO domain name disputes. The user interface employed attention weight-based highlighting. The screen shows a similar highlighted text from a Board of Veterans' Appeals case. In their experiment, the participating users were given a task to perform. Each participant was asked to decide the issue of no rights or legitimate interests, NRLI, in two separate cases and to provide a justification for each prediction. As we'll see in a moment, no rights or legitimate interests is an important issue in WIPO domain name disputes. Two of the four experimental conditions involved highlighting portions of the case texts based on attention weights. The results showed that the highlighting had no effect on the correctness of the predictions. According to Branting, perhaps excuse me, perhaps the most illuminating comments by participants were that they had difficulty understanding the connection between the highlighted text and the issue they were supposed to decide. Although one experiment is not determinative, the finding is a blow to hopes that HAN attention weights can explain legal predictions. Branting recommends that useful decision support should help the user understand the connection between relevant portions of the case record and the issues and reasoning of the case. Legal knowledge would be important in helping users understand this connection. But the question is, how does one integrate legal knowledge into this text analytic analysis? One of the most promising recent research projects is described in Carl Branting's 2020 paper in the AI and Law Journal, Scalable and Explainable Legal Prediction. The authors developed a semi-supervised approach called SCALE for annotating WIPO domain name dispute cases in terms of factual and legal findings. Text annotation involves marking up texts of case decisions or statutes to identify instances of semantic types of information. Types are the concepts of interest in the text, for example, legal issues and case holdings. The types of interest are organized into a type system, a hierarchy of concepts and a relation, so an annotation pipeline can automatically assign some semantics to text. Branting calls it a tag system. The researchers annotated sentences from the finding sections of a small set of decisions in terms of the labels in the type system shown here. The scale labels capture features keyed to the types of findings, issues, factors, and attributes that arise in the WIPO cases involving disputes about domain names. See, for example, the issue of no rights or legitimate interests, NRLI, and its related factor of prior biz use, both highlighted in green. These come from one of the rules governing domain name disputes. The rule states the importance of a bona fide business use of the domain name prior to the notice of the dispute. The attributes also capture information in the text spans about citation and polarity. Here are samples of annotated text excerpts from two cases, factual and legal findings sections. Human annotators assigned the labels shown in the last column. These labels come from the scale type system we saw in the previous slide. The researchers bootstrapped their small set of annotated instances in order to label the sentences in the findings section of all the cases in the WIPO corpus. For any given tag, they represented all the annotated spans with semantic vectors. Semantic vectors employ word embeddings to represent each word's meaning in terms of the most frequent contexts in which it occurred in the corpus. Thus, the vector representations of similar sentences tend to be closer to each other than to semantically dissimilar sentences in this vector space. As a result, each sentence near enough to the mean of these vectors is annotated in terms of that tag. In an experiment, they confirmed that the projected tag annotations predicted case outcomes reasonably well. The resulting predictions achieved reasonable F1 measures. And as a bonus, the tags represented substantive conceptual features with which to explain the predictions. Why is Branting's team pursuing the scale approach? Because they want a system that can generate explanations lawyers can understand, a system that can help the user understand the connection between relevant portions of the case record and the issues and the reasoning of the case. As we have seen, Branting tried using HANs, hierarchical attention networks, but the highlighted portions of text could not help human users to make the connection to the task they were meant to perform. The system did not know what the highlighted portions mean. It needs to identify findings, issues, and factors. That's what scale is intended to provide. Scale is an impressive step toward teasing legal meaning from case texts. It can identify a kind of factor in legal texts, factual patterns that have legal significance. If AI could extract more meaning from legal texts, that could help it to explain its predictions and answers. As I mentioned in my book, Artificial Intelligence and Legal Analytics, I have argued that some of the earlier knowledge-based methods could provide machine learning with concepts and structures for constructing explanations. For example, conceivably, machine learning programs could be taught to identify factors in case texts. Once that had been done, knowledge-based methods could construct arguments and maybe even test conclusions. That's why I find the work on scale so interesting. It's a big step toward extracting meaning from legal texts in the form of these substantive features like factors. Could the scale approach automatically identify factors such as those used in trade secret law? Granting says that it may. It would involve annotating text spans of a representative set of decisions with the scalable and explainable legal prediction factors. Then one would match these text spans to sentences in unannotated cases that are close in the semantic vector space. To get a sense of how hard or easy that might be, here are some examples of sentences from which one can infer that a particular trade secret misappropriation factor is present in a case. These sentences involve 4 factors and come from the Mason case, a trade secret dispute concerning the recipe for a cocktail, Lynchburg lemonade. If similar sentences appear in other trade secret cases, a machine learning program might be able to learn the patterns. Intuitively, however, trade secret misappropriation cases involve more varied fact situations than WIPO domain name disputes. They involve many different types of information and methods for misappropriation. A recipe for a cocktail is just one example of the enormous range of ideas and information that trade secret law can protect. In addition, these cases are heard before all sorts of courts and judges, so the format and stylistics of their decisions would vary. My student, Mohammed Falakmazir, assembled a corpus of trade secret cases. He employed word embeddings to represent the texts. He trained a machine learning algorithm for each factor using a subset of manually classified cases, and he predicted the factors that apply in the cases in the VJAP corpus that we saw before, and achieved F1 values of 0.65. This is some indication that the texts contain enough factor-related signal to be exploited. If machine learning can identify factors in case texts, the factors themselves, these stereotypical patterns of factual strengths and weaknesses, could become an additional feature for otherwise text analytic prediction. A system could provide both text analytic prediction and argument-based prediction as per a VJAP type argument model. Text analytic prediction could provide explanations with legal arguments a la VJAP, including textual arguments for and against the text-based prediction. But wait a minute, you might say, 2 kinds of predictions? What if they conflict? But is that really a problem? Isn't that important information for a legal professional who is assessing whether he or she can rely on a prediction? Shouldn't such a legal professional consider alternative types of predictions and even arguments against a prediction, especially when they are legal arguments such a professional can understand? I think they should. That's my argument, how legal knowledge can assist machine learning. Let me turn now to the second part of my talk, how machine learning can help discover legal knowledge. Here I'm speaking of applying legal text analytics for empirical legal studies. As Michael Livermore and his co-authors have stated, For legal scholars, advances in computational text analysis empower new ways to read and think about the law, culminating in a new approach, computational legal analysis. They survey projects that have applied machine learning to legal texts in support of empirical legal studies. I cite a handful of such projects here, some of the authors of which will be addressing this conference. Why is this a very good time to apply text analytic methods in empirical legal studies? Director Lim has already mentioned some. Higher resolution of the text analytic techniques is one reason. Using document embeddings and transfer-based language models, one can extract more meaning from the text than ever. And secondly, as Dr. Lim has pointed out, there are new comprehensive sources of legal text data that have become available for research, such as the Harvard Law School Case Law Access Project with its 6.7 million cases. Together, these enable evaluating new kinds of legal hypotheses in entirely new ways. At the University of Pittsburgh, we've created a Center for Text Analytic Methods in Legal Studies. As our first activity, we're focusing on drug interdiction autostop cases, DIAS cases for short. Here's the problem. In the United States, police officers regularly stop motorists for violating a traffic law, maybe a broken taillight or running a stoplight. An officer may decide to detain the vehicle based on suspicion that the motorist has drugs in the car. The officer may want to arrange for a police drug-sniffing dog to come to the scene. Under the Fourth Amendment, the officer's suspicion must be reasonable in order to order a canine drug sniff. If not, any resulting evidence can be suppressed. These drug interdiction autostops have led to thousands of cases at the state and federal level, including the US Supreme Court. They also lie at the root of the phenomenon of driving while Black. These stops often result in prosecutions of Black drivers and sometimes violent altercations with the police. In reading these cases, we find that courts rely on certain factors to assess the reasonableness of officers' suspicion. Examples include driver nervousness, the use of a rental car, the use of masking agents to cover up the odor of drugs, prior convictions of the driver, traveling to cities or hubs known for drug activity. For the Diaz cases, we've identified 5 clusters of a total of 34 factors regarding reasonable suspicion, including occupant behavior, occupant status, travel plans, vehicle status, and vehicle contents. Those are the factors of suspicion. But when are they sufficient for an officer to have reasonable suspicion? What is their importance or weight, either singly or in combination? Those are difficult questions to answer. There are nearly 40,000 published decisions involving the legality of autostop searches. Judges, lawyers, and police officers cannot possibly read every one of the cases. They cannot determine how courts in the aggregate view each suspicious factor an officer identified. Processing large amounts of text, however, exactly what machines can do quite well. We are trying to answer the following research questions. In Diaz cases, can machine learning, natural language processing, and statistics identify factors of suspicion, assign weights to them, and assess likelihoods that courts will find facts sufficient for search? Can we identify implicit bias in case language? And then can we find relationships of racial bias and outcomes? If we can do item A, we could answer the question, when are the factors sufficient for an officer to have reasonable suspicion? We've developed a work cycle for analyzing such research questions. It begins with formulating a hypothesis. Then by assembling, annotating, and processing textual data for machine learning, we can evaluate the hypothesis and report our results. Let me focus briefly on the annotation task. As mentioned in part 1, text annotation involves marking up the texts of cases to identify instances of semantic types of information mentioned in the texts that are relevant for analyzing a hypothesis. For example, we are interested in the factors of suspicion relevant to the issue of reasonable suspicion. Our goal is to annotate enough examples of mentions of these factors so that a machine learning model can learn to identify factors in cases it hasn't seen. We employed Gloss, an online annotation environment designed by my colleague Jaromir Savelka. Gloss makes annotating as convenient as highlighting in different colors. Here's an example of how we annotated a case text, the Aiden case. We highlighted a sentence using a pop-up menu to select the appropriate factor with which to annotate the text. The case text with annotations is shown in the middle column. A partial list of factors, color-coded by cluster, is at the left, and a map of the full text on the right. Successful machine learning requires that humans can annotate the targeted concepts in a consistent manner. We always have two humans annotating the same documents. In our case, the human annotators are law students. A detailed annotation guideline and factor glossary help to ensure that multiple human annotators achieve sufficiently high inter-annotator agreement. In addition, we monitored the annotation to resolve any disagreements, and as shown here, our tool enables side-by-side comparison of texts marked up by two annotators. And we have sessions where the annotators discuss and resolve disagreements, often with the guidance of one of the law professors on the team. We conducted a preliminary experiment with 40 cases involving a determination of whether reasonable suspicion was present. We applied the machine learning algorithm logistic regression to train a model to identify the 5 factors and conclusion on the left. We annotated 520 sentences and divided them at random into a training set, a validation set, and a test set. Here I'm reporting the results of training a model with the 260 annotated sentences and testing the model on the 130 sentences in the test set. The model classified these sentences in the test set in terms of the 5 factors and conclusion. As shown, the F1 scores ranged from 0.89 to 0.97, encouraging evidence of the task's feasibility. We have not, however, yet tackled training a model to identify from all the sentences in a case those sentences that express a factor. As to identifying racial information in the autostop cases, we need to distinguish between explicit references to defendant's race and latent or implicit racial information. We have observed some explicit references. In the Aiden case, for example, you see a quote from the dissenting judge who said, "In my opinion, the appellants were the subjects of a blatant case of driving while black." We're not sure how frequently explicit references appear, but we are starting to annotate the cases for racial information. We're also exploring a way to identify latent racial information, but given the time, I think I will move on to finish. So what legal knowledge can machine learning reveal about reasonable suspicion? First, it's important to recognize that we're analyzing the legal standard for reasonable suspicion. Factor weights could help refine this legal standard, which currently is rather ill-defined. Factor weights could help police understand the legal standard. The weights could inform a metric for assessing reasonable suspicion, and conceivably they could even serve as an automated guide to help courts and police determine reasonable suspicion in the field. More importantly, a deployed system of that sort would be a step toward understanding a key point. How well does this legal standard predict the presence of drugs in automobiles? After all, that's the point of the standard. A system could collect data on how well the various factors of suspicion predict the presence of drugs in the automobile. It would reveal if courts are relying on factors that do not predict the presence of drugs, or are relying on certain factors too much, or on factors that are not race neutral. Let me wrap up. As you see, progress in parts 1 and 2 depend on machine learning's ability to identify factors in case texts. So far, even the semi-supervised machine learning applied in branching scale still required manually annotating texts by factors. As a result, I'm focusing my efforts on systematizing and improving human annotation of things like factors. As a law professor, I'm especially interested in whether case text annotation has pedagogical value. Can we use it to teach students something useful about legal reasoning with cases while we generate annotated instances for machine learning? I think so. Another prospect is more disturbing. Can machine learning hallucinate legal knowledge? Recently, I had some experience with OpenAI's GPT-3. It's a transformer language model. It uses an attention function to calculate the probability that a word will appear given surrounding words. Its 175 billion parameters apply greater or lesser weights to some aspect of the data, reflecting what the network has learned. My colleague Jaromir Savelka and I submitted the dog bite hypothetical illustrated on the left to GPT-3. With no training whatsoever, it generated the response on the right. The first paragraph of its response looks rather remarkable. Is it legally plausible? I'm not sure, but it looks legally plausible. And this from a system that presumably has no understanding of the law of dog bites, other than some miscellaneous snippets of legal text in its corpus. The response quickly degenerates into advertising, but hey, almost everything GPT-3 knows, it gets from the web. Fortunately, some of you at this conference know a lot more about this problem of hallucination than I do, and have some idea how to deal with it. So let's remain optimistic. Let's assume that machine learning will be able to identify factors automatically in case texts from diverse legal domains. And secondly, let's assume that there are ways to finesse the problem of hallucinating legal knowledge. In this talk, I've tried to illustrate how legal knowledge can help machine learning, and conversely, how machine learning can help legal knowledge. I believe this is a fruitful prospect for the future of AI and law. Thank you, and I'm happy to take questions.
Thanks, Professor Ashley. Are there any questions?
I see that Thorne has one.
Now, can you hear me?
Yes.
Good. So, Kevin, that was very good. There was an enormous amount of detail there, which I found extremely interesting. Very nice summaries of some recent and important work. Let me pick up one thing, a major point you made, and ask, I think, a critical question about it. So early on, talking about Matthias's work on VJAP, you said if the factors could be identified automatically from text, then VJAP could explain the legal arguments, et cetera, something like that. And then,
Yes.
and that was basically I think the framework of part one of your talk. You then went on to talk about many efforts, Carl Branting's and others, to identify those factors. But here's the question that I think wasn't answered. You were assuming a huge amount of legal knowledge that could operate with those factors. In this case, the trade secret domain, you've accumulated that legal knowledge over something like 20 or 30 years, I think. So isn't there still a very serious knowledge acquisition bottleneck in putting together the legal knowledge, even if you can identify the factors from texts?
Well, the knowledge is captured in the domain model, like you see on the screen. And yes, we've been using and improving the model over a long period of time, but creating it has not been an effort that required a tremendous amount of time. And I don't intend to suggest that I think that this kind of information can be acquired automatically. So yeah, it's going to take some time to create such a model. And such a model is basically an interpretation of the area of law. So for example, if you look at the work of Benj Capon and his colleagues, their model is a little different, their values are a little different, their factors and so forth are a little different. But it hasn't been a Herculean effort to create such a model, and I think it can be done in a fairly straightforward way. And also, one doesn't necessarily have to tackle all of the issues in the domain of law. One could focus on particular issues that are that tend to be litigated and that are interesting for other reasons. So I grant your point. It takes time and effort and care to put together one of these domain models. But I still think it's doable and connectable to the cases as long as the factors can be identified. Jason has a question.
Hello, can you hear me?
Yes.
I would like to find out, in your part one, you're talking about the opportunities to use machine learning in order to collect the information that we need in order to do this kind of factor-based prediction of case outcomes. I'm wondering if there's an analogous area of research into using machine learning to get the information that we need out of statutes in order to create models of statutes, if you're familiar of any work that's being done in that side.
My understanding is that despite years of effort in the AI and law field, that no one is extracting logical rules, for example, from statutory texts, except in rather limited areas. So, for example, in the civil engineering field, one sees examples of programs extracting some logical rules that define the area required for courtyards associated with buildings and so forth. They tend to have readily identifiable quantitative information, references to various metrics and so forth, which presumably helps in the task. But in general, we haven't succeeded in extracting rules from statutes. What I'm talking about here, though, are as extracting these stereotypical patterns of fact from the case texts. I don't say it's easier, but we've had more, I think, success than in attempts at extracting logical rules from statutes.